Lia.
Thank you, Chairman. Okay, in a short talk today, I'd like to cover the submissions we've received in relation to the environment. And I suppose the general questions are, as you see in my first slide there, what is the environment? Why should it be protected in the Constitution? And how should it be protected in the Constitution? I should say at the outset that there have been a huge number of submissions on this subject, well over 100. I'm not sure what the current figure is on that. And in addition, there's a real sense of immediacy and urgency in the submissions. There's a sense of threat, unprecedented threat to the Irish environment. Indeed, we even received submissions from children on this topic who were concerned. As the Green Party submission put it, in 1937, the drafters of the Constitution did not foresee such an extreme rate of progress in the economy, which would actually threaten man's relationship with the environment. And it's not surprising then that, in fact, the word environment doesn't appear in the Constitution. At least it doesn't expressly appear in there. It could be argued that, to some extent at least, the environment or environmental rights are already protected in the Constitution. And I just mentioned there on my slide, for example, we have Article 10, which mentions the ownership of natural resources, which vest in the state. Article 40 protects, for example, the right to life and health. So implicitly you could say there is therefore the right to a healthy environment. And Article 43 deals with the balance between private property and the common good, which is a topic which arose in some of the submissions on the environment, as I will explain in a moment. Right, so what is the environment? I mean, there are many components of the environment, and interestingly, various submissions emphasised different components of the environment which they were concerned about. I mean, there are the basic physical components such as air, water or soil, and indeed those of you who live in Dublin will be acutely aware of water rights issues at the moment, and indeed those of you who live in the Midlands as well. There is biodiversity and wildlife, and just to give you an idea of the variety of submissions on this kind of subject, some people were concerned that we should protect our native species. Some people were concerned about bees and the pollination services they provide for our crops. Some people were concerned about animals, indeed not just wild animals, but pets and so on. Indeed, the German constitution has a provision on animal welfare or animal rights. There's, of course, the food chain. The food we eat is all intimately bound up with the environment. There's landscape and all the visual components. There's the built environment. So that's just a flavour of what we might like to protect here. And then, of course, there are the environmental values, or the elements which make up a good environment. As I've mentioned, there's health and safety, and indeed many constitutions around the world and many constitutions in Europe refer to the right to a healthy environment. So the environmental protection there in their constitutions is intimately linked to health. There's also the notion of ecological balance. That appears in the Philippines constitution, I think somebody in the submissions pointed out. Even natural beauty is protected in some constitutions. I think Hawaii was the one that was mentioned there. There's the notion of heritage. And there's also this notion of community which appeared in some of the submissions which were particularly concerned with having better open access to the countryside, not just for hill walkers and the like, but for everybody. The sense, in other words, that private rights in the environment were not adequately balanced by the common good in allowing people to enjoy the environment. And to enjoy, you know, the shore and the cliffs and the mountains and so on. So I suppose looking at these environmental values, it's fairly obvious why people have been writing in wanting to put the environment or the word environment in the Constitution. Some people rightly pointed out that the environment sustains our life, so it's even more fundamental than fundamental rights, because if we don't look after that, nothing else will follow. People refer to human well-being. There was the physical component of human well-being, the mental component of human well-being. Some people even mentioned the spiritual component, that it was like the soul of the nation. And there's also the notion of Irish heritage, that the environment somehow defines us as an Irish nation, and that we have a duty to future generations to preserve it. So if we were to mention the environment in the Constitution, and I'm not suggesting today that we should necessarily do that, but it's a topic that we should perhaps look at, how would that be done? There are many different ways in which it might be done, and in which it has been done in various other countries. At the most general level, you might want to put a principle or an aspiration in the Constitution, such as the notion of stewardship of the environment or sustainable development. Some people would say that's too general and it's not sufficiently enforceable, so they argue for rights in this area. The question then is it the right of the environment or a right to the environment or to a particular level of environmental quality? And just to give you an example there, one of the people writing the submission had recently returned from Ecuador, where he or she pointed out that the Ecuador Constitution has a provision referring to the right of nature to exist and regenerate its vital cycles. However, it's much more usual, for practical reasons, to vest rights in the environment in individuals or in the public at large, because individuals and the public, and indeed organisations such as NGOs, can enforce rights on behalf of the environment, if you like, or on behalf of the public who want to protect the environment. You might, on the other hand, look as well, in addition or alternatively, to duties. So, for example, the Constitutional Review Group, which Peter will mention later on, referred to the notion of a duty on the state or public authorities as far as practicable to protect the environment. And indeed, the EU Charter on Fundamental Right seeks to place a similar duty on the EU or European Union institutions. You might refer to the duties of citizens. We all have a duty, a responsibility to protect the environment, which correlates with our right. Some submissions refer to a trustee model, again going back to this notion of property and the common good. They were saying that landowners in this country really should have a covenant with the citizenry at large that they will adequately steward the land in the interests of the whole public or the citizens, including future generations. Just some other themes which arose then were procedural rights. In other words, moving away from the substantive notion of environmental quality, there are certain procedural rights you might give people which, if exercised, would tend to protect the environment. And these tend to be usually mentioned in three, because the Aarhus Convention, which Ireland has recently ratified, incidentally, has a sort of a triad of procedural rights. And to some extent we have these already in Irish law, but Irish law needs to be beefed up and improved in order to protect these rights better. And the question then is, would you want to put these in the Constitution or not? But just to mention them, they are the rights to information, in other words, information on the environment from government authorities and so on, the rights to participation in environmental decisions such as planning decisions and strategic environmental decisions, and the rights to access to justice so that you can get proper, timely, effective and inexpensive review from the courts on environmental matters. Just to mention as well, there were other submissions such as some people actually suggested inserting a crime of ecocide into the Constitution. We were discussing yesterday whether there are any other environmental crimes other than blasphemy, and some people felt so strongly about this that they felt there should be criminal measures introduced in the Constitution. So I suppose that's all I have to say for the moment, just to give you an overview of those submissions and of the concerns that have been raised, and I'd be more than happy to take any questions later on.
Thanks, Lia. So next up is Clodagh Harris, dealing with economic, social and cultural rights.
Good morning. So what I'd like to do this morning is to just give you a flavour of what was covered in the submissions on economic, social and cultural rights, and also an overview of some issues that are raised in debates on this topic. So, for example, the convention received over 150 submissions on economic, social and cultural rights. Now, I don't have time to go through each and every one of them, or we don't have time here to go through each and every one of them, but just to suffice to say that there was huge interest in this area. And it was also a topic that was raised at the regional meetings on a number of occasions, both in Cork and in Galway. So the submissions, by and large, called for these rights to be incorporated into the Irish Constitution. And I suppose before going any further, what I would like to do is maybe reflect on what exactly these rights include. And I'm hoping that the gadget works. Doesn't seem to be. Anyway, I can remember them. There. Oh, here we go, pardon me. The gadgetry is very sophisticated here, unlike what I'm used to. So For the most part, they're outlined in the International Covenant on Economic, Social and Cultural Rights of 1966, and this includes, and I'm not going to play PowerPoint karaoke to cite one of our experts, namely Eoin O'Dell here yesterday, but they include the right to social security, the right to an adequate standard of living, which includes adequate food, adequate clothing and adequate housing. I think it's very important for me at this stage as well to highlight the volume of submissions that were received regarding to housing in particular. And indeed rights regarding health. Again, a number of submissions pointed out rights to health, both physical and mental health, and right to education, which is protected in the Constitution, and cultural rights. And Ireland's ratified this convention in 1989, but the provisions have not been incorporated into Irish law. And the submissions, as I said, advocated for these rights to be incorporated into the Irish or into the Constitution. And they gave a variety of reasons. And again, I'll give you a flavour of what these reasons were, why they wanted to see these incorporated. And I kind of add a health warning saying that it's not an exhaustive list. So the submissions argued that incorporation of these rights would afford greater protection to the vulnerable in society, particularly in times of austerity, that it would also help Ireland meet its legal obligations in this area and bring it into line with what's happening in other countries. It would help promote the enjoyment of other rights. So, for example, can we enjoy the right to vote, etc., without having economic and social rights? It would also give citizens a remedy for alleged violations through the courts, and also submissions mentioned that it would empower civil society, etc. So, as I said, not an exhaustive list, but a flavour of, I suppose, the reasons why the submissions were advocating for the incorporation of these rights into the Constitution. And I suppose another topic that was raised on a number of occasions was that it would frame discussions on a rights basis rather than a needs basis, and in particular would provide a framework for holding the government to account in how it protected, respected and fulfilled its obligations to these rights. So in terms of the convention, should you choose to pick this as your topic for your future deliberations, there are obviously many issues for consideration that perhaps were not raised in the submissions. And again, I stress that this is not an exhaustive list, but if you were to look at this, I would imagine that you would be discussing and looking at how economic and social rights are currently protected in the Irish system. So, for example, there is direct protection currently of some economic, social and cultural rights in the Constitution, namely, for example, the right to free primary education, the property rights. Also, there are indirect protections in the Constitution through the way in which Articles 40 to 44 have been interpreted to allow some level of protection for economic, social and cultural rights. I'm thinking here of the doctrine of unenumerated rights. And also another very important area for discussion would be around the whole area of Article 45, which was raised in a number of submissions, which contains directive principles of social policy. And there would no doubt be a level of debate around how effective that article has been, or whether it is sufficient as an article to protect economic and social and cultural rights. So the other issue for consideration would be, for example, how should these rights be incorporated into the Constitution? And indeed, some of the submissions gave details on this. So, for example, some argued that individual articles could be inserted into the Constitution, protecting some or all of these rights. Another submission suggested that Article 40 should be amended to include economic, social and cultural rights as personal rights. Others referred to amending Article 29, which covers the application of international agreements in domestic law. And indeed, one other also, or maybe two, referred to the inclusion of a Bill of Rights, which my colleague will be discussing later. But even to take a step back from how they might be incorporated into the Constitution, there is another kind of debate there as well around, and it's a point that was raised in Lia's presentation, around principles or rights, and whether or not the debate would need to be held as to whether you have guiding principles that would, I suppose, guide the Oireachtas in this area, or would you have enforceable rights which would involve using the courts and in this regard? And I suppose the questions around that then, if part of that debate would then also look at the separation of powers doctrine. So, for example, the debate there would look at rights enforceable by courts, but if we are using the courts to do that, are we binding the hands of the Oireachtas in terms of allocation of resources? And that then, I suppose, brings me on to another point that has been raised in debates on this issue, is the whole issue of resources in terms of enforcing these rights. I hope I have given you a flavour of what's covered both in the submissions and in the wider debates in this area. Again, I stress it's not an exhaustive list, but it should give you hopefully an overview, and I wish you the best with your deliberations and your decisions. Thank you.
Right, hello everybody. My brief is to summarise the submissions in the area of church and state, and I suppose this is perhaps the area that most overlaps with what you've been dealing with this weekend. And with all due respect to my colleague here on the right, I will engage in some Facebook karaoke here. So basically there are a large number of submissions, a particularly large number of submissions, I have to say, in the last week or two on this theme. And some have simply called for leaving things as they are, it should be noted. Quite a number of submissions have just said, a state like ours should have some reference to church, to the Christian religion, to the Catholic Church in its constitution. So there's a large number that just don't want to change. But of course there are a very large number of the submissions that are calling for some form of change in relation to this. And they can be grouped into 4 areas, and in your workbook that's what I've sought to do. So the first of these relates to the religious oath for office holders. So what you have on the PowerPoint there is the relevant section from the Constitution, the relevant article, Article 31.4, which is what is required by those who want to become members of the Council of State. To become a member of the Council of State, that's the oath that they have to swear. And this has become an issue quite recently, as you may have seen in the media, where some of the members of the existing Council of State have come out publicly saying that this oath should now be secularised. It should not be a requirement for members of the Council of State that they swear an oath to Almighty God. This is not just an oath that applies to members of the Council of State. There are similar oaths that apply to other office holders in Ireland, but this is just an illustration of the issue. So one question that the Convention might want to consider in future deliberations is whether we should secularise the oath required of office holders. The second theme that came up very strongly relates to the preamble to the Constitution. And it's been mentioned a lot throughout your deliberations from the get-go, but just to give you a flavour, if you haven't had a chance to open the front page of your Constitution, here's just the opening text in the preamble: "In the name of the most holy Trinity." And it goes on at the end there, "humbly acknowledging all our obligations to our divine Lord Jesus Christ." So that's the preamble that is in our Constitution. And the interpretation by the lawyers is that it would be possible for us the Constitution Review Group considered this question in 1996 and said it would be possible for us by referendum to amend that were we to want to do so. So a question there is, the preamble is much longer, but this is just the opening text, the relevant bit really, whether that religious reference should be removed from the preamble. That's a theme that's come up in quite a large number of submissions. And then the third theme that's come up a lot is whether we should remove all religious references throughout the Constitution. And as it happens, Eoin O'Dell earlier on referred to Article 44, Section 1. Well, here it is. So this is currently in there. There's much more in Article 44, but I don't want to overload the PowerPoint. So Article 44, Section 1, "The state acknowledges that the homage of public worship is due to Almighty God. It shall hold his name in reverence and shall respect and honour religion." So a large number of submissions have been asking the question whether that and any other references to religion should be removed from the Constitution. A very meaty question that might be worth considering. And then the final of the 4 issues that seem to come up in the submissions was over the sort of the wider policy question of separating church and state. a question which was raised initially in just one submission, but there have been a large number since this text was drafted for you, is whether religious orders should continue to have a role in managing schools and hospitals. And this is an illustration of a point that was made by the Human Rights Committee in 2008, where it expressed its concern about the vast majority of primary schools in Ireland that are privately run denominational schools. So there is a question there that's been put out by a large number of submissions about whether that should be changed. So this is probably the most straightforward of the issues you've heard so far, but nevertheless quite weighty if you wanted to consider it. And I'll now turn to Eoin.
Good morning. One of the possibly surprising issues that came up in the course of the 2011 general election was political reform. And it was surprising because everybody thought we'd be talking about the economy, and we did talk about the economy. But one of the things that we saw was people tended to put great emphasis on the idea of political reform, that the political system was broken. And so what we've seen in the course of this convention is that issues of political reform have been important. And it's, I suppose, not surprising then that many submissions we received were on political reform. Now, the Constitution performs a number of functions, one of which is to set out ideals and values in society, one to set out the rights and duties of citizens. But a very important function that a constitution has is to be the sort of political rule book. And so if you want to change the rules or the way in which the game of politics works, changing the rules makes sense. So we can see that the constitution is central to politics and to political reform. A word of, I suppose, warning is that maybe constitutions aren't everything, and that culture also matters. And so we could see a number of years ago when local government was put into the Constitution, people thought that this would empower local government. But it just putting something into a Constitution doesn't necessarily empower it. And changing something in the Constitution doesn't necessarily change the way in which politics might work. Now, so we received a large number of submissions on political reform, and I'm going to go through these in no particular order, but these were areas that it was suggested the Convention should consider and think about. One is the role and power of the Ombudsman. Now, the Ombudsman is an independent office, which isn't, as far as I know, explicitly mentioned in the Constitution. But the most recent office holder complained that her reports were often ignored, and so the Convention might want to consider whether the powers of the Ombudsman should be extended and whether this should be explicitly put into the Constitution. Perhaps very unsurprisingly, an issue that came up in many of the submissions was the reform of the Seanad. Probably everybody agreed after the referendum that the Seanad as currently constituted doesn't work terribly well. But we might ask whether we could have meaningful reform within the confines of the Constitution, or whether the Constitution should be changed to enable extensive reform of how the Seanad operates. Another issue that has come up and came up in the context of the Seanad referendum was the reform of the Dáil. So many suggest that the Dáil doesn't provide sufficient oversight of government, and the Convention has considered some of these issues, but has done so tangentially. So we could try and think about how do we reform the government, and does this require constitutional reform? How do we reform the Dáil and its relationship with the government, rather? Another issue that was suggested was the appointment of judges. So it appears that judges are appointed in an essentially political way, and that this may be in some way offensive. How they're appointed should have an impact on their independence, and so again we could think, do we want to remove the role of politics from the appointment of judges? The role and power of the Controller and Auditor General is another thing that came up. The CNAG audits state spending. Now, one of the things that people complain about is that his auditing of state spending is essentially retrospective, And so we could change the constitution to empower the CNAG to look prospectively at current government policies and see whether these would provide value for money or not. Again, I suppose as a result, perhaps something that was highlighted because of the Shannon referendum was the referendum process itself. And so we could look at, this could extend from fundamental issues such as whether we need a referendum for what might seem to be minor changes in the Constitution, whether we want to keep referendum for changes to the Constitution. Ireland is obviously quite unusual in having that, but I don't think anybody wants to remove the referendum. And just an examination of the way in which referendums are carried out, whether the referendum commission is something that works, whether it enables people to understand and engage fully in referendum debates and campaigns. Local government is something else that came in on a large number of submissions. It's mentioned in the Constitution, but as I said, it hasn't really been empowered by the Constitution. When it's mentioned, it's just that it mandates that you have local government elections every number of years. But we might think about whether local government's powers should in fact also be extended and explicitly written into the Constitution. The role and the power of the President was also raised. The President is, as we know, an essentially non-political office, but that role has been stretched somewhat by the last three incumbents. And some argued that, and some submissions argued that the President should have a clearer and more active part in public life and in policy debates, this could improve the role of the President if some of the restrictions were removed. Freedom of information was also raised by some. The freedom of information regime has been weakened somewhat in the last decade, and so some have argued that those rules should be reinstated. Now, whether that requires a constitutional change or not is debatable, but some have argued that if you put this into the Constitution, then it would remove the ability of governments to change the rules on freedom of information as it might suit their needs and ends. Now, each of these issues that I mentioned here probably constitute quite a significant area for the Convention to explore on their own. So it would seem to us that it would be difficult for the Convention to make recommendations on any of these issues unless they were isolated and considered on their own, that the Convention itself couldn't consider all of these and make meaningful recommendations in the context of a single session. Okay, thank you.
Okay, hi. I was asked to talk about family and moral issues, where there were we grouped them into two different areas depending on which part of the Constitution they talked to. So the first one, where there were numbers of submissions, was Article 40.3.3, which is the one that a lot of people in the room will be familiar with, because we had a lot of debate about legislation and so on in recent months about it. And basically it's about the right of life to the unborn. So it came under a lot of scrutiny under the Protection of Life during a pregnancy bill, which received unprecedented amount of, I think, dull debate and was very controversial. Yet many sides of that debate have expressed dissatisfaction with the actual constitutional piece that is in there, and many different sides have asked that there would be a referendum to change it. So if you go through that, those on the pro-life side argue that the legislation that was recently introduced, which allows abortion on the grounds of suicide, that could be abused and could open up abortion on demand, and therefore so there are arguments there that this article should be repealed. Others in the kind of the middle ground favour access to abortion for fatal fetal abnormalities, or if somebody has been raped or in the cases of incest. So again, some of them would argue for a referendum on this. And then those on the other side, on the pro-choice side, argue that women's health should be the primary consideration, and that access to abortion should just be regulated and permitted by law. So, there is certainly from, all the various perspectives, or a lot of the various perspectives anyway, there's arguments that revisiting this article could allow us to reconsider it again from the bottom up. There was one other submission which was related perhaps, which was the right to die, which isn't actually in the Constitution at the moment, but could theoretically be in here, and the right to an assisted death and so on. So if this were to be examined, that could be put in to that area as well. So the second one, the second article in this area where there was a lot of submissions, I think there was 19, was on the definition of the family. And the article there is up there in front of you, just the part of it, which is that the state pledges itself to guarantee with special care the institution of marriage on which the family is founded. And the arguments here really are the effect of this is that non-marital families are not constitutionally entitled to protections in the realms of tax, inheritance and social welfare that are granted by Article 41. So on one side, a lot of the submissions are arguing that the Constitution is thus very out of step with the reality of many families in Ireland today, where up to 30% of children are being born to non-marital families. So they would like to see the constitutional definition of the family to be reviewed in the light of changes to Irish family life over the last few decades, and ultimately to reflect the range of families that Irish children now live in. Now, on the other side, others believe, of course, that the status quo should remain, and that they argue that the institution of marriage is mainly child-centred, it's not adult-centred, and therefore we shouldn't be looking at changing it in this way. But there was also a lot of arguments that the Constitution is inconsistent with the European Court of Human Rights and with its definition of the family. And I think the basic thing is that the ECHR, the European Court, recognises what it calls the de facto family. So in other words, whatever family it is that the child finds themselves living in. So it doesn't matter whether it's marital, whether it's non-marital, whether you're adopted, whether you're not adopted, whether the family is gay or straight or whatever. What matters is the actual de facto family that the child finds themselves in. But in the Irish Constitution, the court has ruled that the de facto family is not recognised, and that we must recognise the family based on marriage, and that's because of the interpretation of this part here of the Constitution. So essentially, like a lot of the submissions would argue, it means that unmarried Irish fathers have far fewer rights than they would in many other countries. So do some adoptive children, surrogate children, stepchildren, children in gay families, and so on. Now, there have been changes since the 1980s when essentially unmarried fathers had no rights and their children could not inherit. Now fathers can apply for guardianship, but the submissions argue that that's the rub, that the unmarried fathers have to actually apply for guardianship and there's no automatic rights. Although I did hear on the radio on the way in this morning that Alan Shatter is proposing a legislative change that would mean if an unmarried father had been living with a woman for a year, that he could have automatic guardianship. But that probably goes back as well to a lot of the submissions which say that just putting it in legislation, what is given in legislation can be taken away, and that constitutionally the children in non-marital families are different to the children of marital families, and that's what these people want to look at. Now, there is other legislative protections under the civil partnership legislation, for example, But again, the submissions argue that this is not constitution protection. And it works in other ways. There was one of the submissions pointed to a recent court case where a very wealthy married man had a child outside of that marriage, and the mother went looking for a lump sum to help her raise the child, and the judge ruled that he couldn't order a lump sum to be given because doing that could affect the position of the first family, and it was the first family who were married who had the constitutional protection. So there's different ways that this comes in. So I think really what people are saying is that they would like us to look at the European Court of Human Rights, which asks if there are real family ties, not whether or not there's a marriage certificate, and therefore to look at the de facto family. And then other parts that a couple of people mentioned were the rights of children. As we saw in the recent children's referendum, it's more difficult to protect children who are being abused in a marital home than children who are being abused in a non-marital home. But again, there will be legislation about this, but it's not really entirely clear how that's going to go about it. So I think at the end of the day, one of the submissions said a lot of countries do place a value on marriage. You know, they do grant extra tax breaks and so on. The European Court of Human Rights says it's okay to do that, to protect marriage, but it just doesn't like you discriminating against others while you're actually doing so. And one of the ones that basically said, look, if you have children or grandchildren who are not from a marital family, then they're constitutionally different to the children who are from a marital family. And is that something that you want to look at or not? Okay, thank you.
Thanks, Jane. And now a particular pleasure to introduce Dr. Suzanne Egan from UCD, who's going to talk about the Bill of Rights.
Well, thanks very much. I know my brief is to speak about a Bill of Rights, but I know that the most important aspect of my brief after 5 excellent presentations is to be brief. So I've been asked to speak about one submission to the Convention that in effect argues that the Constitution needs a new Bill of Rights and that the Constitutional Convention is actually obliged to consider this matter because its mandate requires it to have appropriate regard to the Good Friday Agreement in its deliberations. So that, of course, begs the question, what is the relevance of the Good Friday Agreement to a new Bill of Rights for the Irish Constitution? Well, the Good Friday Agreement does contain obligations on both the governments of the United Kingdom and Ireland regarding the protection of human rights. In the agreement, the United Kingdom government made a commitment to make the European Convention on Human Rights part of its domestic law and to establish a Human Rights Commission for Northern Ireland, and that commission would in turn consult and advise the UK government on a Bill of Rights for Northern Ireland. Under the heading then, Comparable Steps, in the Good Friday Agreement, the Irish government also undertook to do a number of things. These include establishing a Human Rights Commission, and crucially, as far as the submission to the Convention is concerned, it also committed, and the wording, the exact wording from the agreement is on the slide, it also agreed to take steps to further strengthen the protection of human rights in its jurisdiction, and that the government will bring forward measures to strengthen and underpin the constitutional protection of human rights, and that those proposals would draw on the European Convention on Human Rights and other international instruments in the field of human rights, and that the question of incorporating the ECHR would be further examined in that context. The relevant provision of the agreement finally goes on to say the measures to be brought forward by the Irish government would ensure at least an equivalent level of protection of human rights as will pertain in Northern Ireland. The agreement also provided that the 2 newly established Human Rights Commissions, the Northern Ireland Human Rights Commission and the Irish Human Rights Commission, would also consider, amongst other matters, the possibility of establishing an all-island Charter of Rights. So we have a number of commitments from both governments in the agreement. So the submission before the Convention argues that even though some of these measures have been implemented, and they would include the establishment of a Northern Ireland Human Rights Commission, the Irish Human Rights Commission, and incorporation of the European Convention on Human Rights in both jurisdictions, that there is still an outstanding implied obligation stemming from the passage on the screen in the Good Friday Agreement to improve the protection of human rights in the Irish Constitution. And so the submission goes on to argue that the best way to achieve that would be for this Constitutional Convention to consider and propose a new Bill of Rights for the Irish Constitution, but that since that would be an extensive task, the submission acknowledges, the Convention should actually ask for a fresh mandate to allow it to conduct this work. Now, as I see it, in considering whether to move on this specific submission, I believe the Convention would need to give careful consideration to the following issues and counter-arguments. The first is whether there is, in fact, an outstanding implied obligation stemming from the wording of the Good Friday Agreement on the Irish Government to adopt a Bill of Rights in the Republic of Ireland, or amend the Constitution to include a new Bill of Rights. The submission argues that the obligation stems from the promise by the government to strengthen and underpin constitutional protection of human rights. Arguably, that commitment has already been achieved through the incorporation of the European Convention on Human Rights into legislation, albeit at a lesser level of commitment than constitutional protection of human rights, and that the commitment is in fact ongoing through the specific items being considered by the Constitutional Convention. As far as the argument that an equivalent level of protection must be achieved, the fact is that there is no Bill of Rights yet for Northern Ireland. The Northern Ireland Human Rights Commission delivered its advice on this matter 5 years ago to the United Kingdom government, and successive governments have refused to proceed or to forward a bill. Therefore, it's probably difficult to reach any other conclusion other than that existing rights protections in the Republic at least are already equivalent to those that pertain in Northern Ireland, and arguably, in fact, exceed the equivalence commitment at the moment. The second issue would be, as I see it, whether a Bill of Rights is actually necessary or feasible. The submission doesn't specify in what way constitutional protection of human rights lags behind other countries or fails to meet international standards. And usually when calls are made for bills of rights, an instinctive reaction might be that that always sounds like a good idea. But there is a good argument to be made that the existing infrastructure of rights protection in this country is quite extensive. It's important to bear in mind also, I think, that opening up a full-blown process on a new Bill of Rights is likely to be divisive, resource-intensive, and may ultimately founder, as has been the case so far in Northern Ireland with respect to the Bill of Rights and with respect to an all-island Charter of Rights, which was also, as I mentioned, mooted in the Belfast Agreement. While consideration of further constitutional recognition of discrete rights and indeed discrete categories of rights, as has been discussed already today, might make sense, the idea of devising an entirely new Bill of Rights might not. And then the third issue, if the submission were to be accepted by the Constitutional Convention, if it was decided to actually move on a new Bill of Rights, I think a consideration should be given as to whether the current composition of the Convention would be appropriate to consider this matter. And by that I mean the point here would be whether serious consideration should be given to including room for more direct participation by civil society groups in that kind of work. I hope that helps. Thank you.